This document looks harmless, but a single mistake on it could cost you over $10,000. Being a landlord in California has always been complex, but in 2026, it has become a legal minefield. There are at least 5 new change laws that most self managing landlords and even some professional managers are getting wrong right now. Today, we're going to walk through those 5 landmines, and I'm going to show you exactly how to avoid them. Hi, I'm Larry Fleischman, and my company, Southland Property Management, is obsessed with compliance. Why? Well, because in LA and Ventura counties, a single legal mistake can cost you more than a year of rental income. Our job isn't just to collect rent, it's to build a shield around your investment. I'm not an attorney, so I'm not giving legal advice, but as a property manager, I act solely in the best interest of my clients, prioritizing their needs well above my own. My commitment demands trust, loyalty, care, and honesty in managing your investment. So let's get into the 5 biggest mistakes we're seeing landlords make right now. Landmine number 1, the outdated lease. Look, your lease is not a set it and forget it document. As of January 1st of 2026, your lease has to be updated to reflect the new appliance habitability standards under AB 628. If your lease still says the tenant is responsible for the refrigerator, you're non-compliant. If a tenant's refrigerator breaks and they lose food, you could be on the hook for damages. Your lease is the first line of defense. If it's outdated, you have no defense. Landmine number 2, mishandling the security deposit. This is a huge one. Under new AB 414, you can no longer charge more than 1 month's rent for a security deposit, regardless of whether the unit is furnished or not. And the rules for returning it are stricter than ever. If you're 1 day late returning the deposit or your deductions are not documented perfectly, a tenant can sue you for up to twice the amount of the deposit and penalties. For a $3,500 rental, that's a $7,000 penalty. Landmine number 3, ignoring fair housing laws in your marketing. You write a rental ad that says perfect for young professional couple or not suitable for children. You think you're being descriptive, but you've just committed a major fair housing violation. Familial status and marital status are protected classes. Using this kind of language can lead to discrimination lawsuits with massive penalties. Your marketing has to describe the property, not the person you think should live there. Okay, landmine number 4, the DIY eviction notice. Your tenant is late on rent, so you download a 3-day notice from the internet, you fill it out, you tape it to their door. You've just made a critical error. In many parts of LA County, that notice also has to be mailed. And if you miscalculate the rent amount by even $1 or fail to include specific legal language required by local ordinances, a judge will throw your case right out and you'll have to start the entire process over again. An invalid notice is worse than no notice at all. On to landmine number 5, no disaster plan. This is the newest and most overlooked landmine. Under SB 610, if your property is in a declared disaster area, like the recent fire zones, you have immediate legal duties. You must halt rent collection, allow lease termination, and provide right of return. If you don't have a written protocol for this and you fail to act, you are in breach of state law. And I live out of state is not a legal defense. The common thread here is that these are not minor technicalities. These are high-cost mistakes. In California, the law assumes that as a landlord, you are a professional, and it holds you to a professional standard. Ignorance of the law is not a defense, and a single mistake can cost you tens of thousands of dollars. If this video has made you feel uneasy, that's a good thing. It means you understand the stakes. I want to help you get peace of mind. My team will perform a free 10-point compliance audit on your property. We'll review your lease and your current procedures with respect to the new 2026 laws and tell you where you might be exposed. Look, this is not a sales call, it's a risk assessment, and it's completely confidential. So to schedule your free audit, just click in the link in the description or email us at info@southlandpm.com with the subject Compliance Audit. Don't wait to find out if you have a compliance problem from a tenant's attorney. The best time to fix these issues is right now. Well, if you found this helpful in any way, please be sure to subscribe, because in our next video, we're going to shift gears and talk about the money side of things, how to maximize your rental income, and what small upgrades deliver the biggest return on investment. Thanks again for watching. I'm Larry Fleischman, and remember, stress less, earn more. That's what Southland's for.